to have some people join us, and then we will get started.
For those of you just joining, we're just going to give things another minute or so to allow other folks to join in, and then we'll be jumping right into the presentation. Thanks for coming today.
Level 2, I think we have a lot to cover today. So Lisa, if it's okay with you, I'll kick it off.
Sounds good.
Great. Thank you everyone for joining us today for our presentation, 2025 Legal HR Compliance for Healthcare Providers. Today, my colleague Lisa and I will discuss the many employment law issues impacting healthcare providers in 2025. My name is Allison Leone. I'm a partner in the healthcare industry group here at Saul Ewing, resident in the Princeton office. And Lisa and I work together a lot on employment issues, and Lisa is a partner in our labor and employment group, and she's resident in our Philadelphia office. Before we dive into the substance of our program, we have a few housekeeping items that I just want to go through with you. The first is questions. Questions can be submitted through the Q&A tool at the bottom of your screen. While we will do our best to answer all the questions submitted in the webinar, if we can't get to it, we will certainly send you an email after the presentation and see if we can help you then. CLE. The program is eligible for one distance learning substantive CLE credit in a number of states. In order to verify your participation and receive your certificate of attendance, you'll need to complete a brief continuing legal education verification survey and note the numeric codes provided during today's webinar. These codes are a part of our requirement and will be announced verbally. The verification survey link was included in your reminder email and is also linked in the resources tab found at the bottom of your Zoom screen. Please be sure to complete the survey within the next 5 days. The webinar recording and handouts. In the next few days, you will receive a follow-up email that will include links to the webinar recording, supplemental presentation materials, and CLE information. Legal disclaimer, the provision and receipt of the information in this program is not legal advice, does not create a lawyer-client relationship, and should not be acted on without seeking professional counsel who have been informed of the specific facts. And with that, let's begin.
Hello, everyone. Good afternoon to some of you, and believe it's still good morning for some of you as well. So covering all time frames here. We have a lot of content to get through and a lot to cover. I tend to be a fast talker. I constantly tell myself to slow down in my head. It doesn't always work in practice. So if you have a question, like Allison said, please put it in the Q&A or in the chat, and we promise we will circle back to it during the presentation or if needed after the presentation. So I think all of you who are joining us today understand, whether you're in a small practice or a large hospital system, that it's important to pay attention to all of the many changing and evolving employment laws that impact your employees wherever they may be located, and that having effective hiring, employee management, and issue spotting can not only improve productivity and help get the work done, but it can help prevent employment practices liability issues. So when we have the legal compliance coupled with consistent policies and practices, we're going to hopefully reduce employee complaints and avoid lawsuits, which reduces your legal fees. And I tell everyone I work with that while I think all of my clients like me as a human being, I know they don't want to have to talk to an employment attorney in most cases, but we are here to support you, and believe it or not, my goal is to help you avoid litigation. And of course, if it does happen, then we're here to work through that as well. Next slide, please. So we're going to start with a very brief overview of some federal statutes. I promise we are not going to spend the majority of this presentation going over Title VII, which I'm sure you're all familiar with, but we do want to just touch base and give an overview of, from a federal standpoint, what we all need to be considering, and then just know that there is, a state, mirroring statute wherever you may have your practice located. There's a state and probably local version of what we're talking about at the federal level, but we want to start with identifying some of these laws so that we can think about the issue spotting that we need to be having as managers, as HR, as in-house counsel, as practice owners, right? When we do that issue spotting proactively, that's how we avoid falling in the hot seat. Next slide, please.
So we can't have a healthcare related presentation without discussing some HIPAA. So at a very high level, HIPAA applies to both covered entities and business associates. Covered entities are health plans, healthcare clearinghouses, and healthcare providers who transmit health information in an electronic form. Business associates are people and companies that provide services to covered entities and use or disclose protected health information in that relationship. A lot of times it's very obvious if you are a covered entity or a business associate, but that's not always clear. And that's something that we can help you navigate and figure out whether or not HIPAA applies to you. Protected health information is what we're looking to protect, right? And that's individually identifiable health information transmitted in any form. It's usually information related to that proves that this person is getting some sort of health treatment, right? So you have to be careful. It's not only just names, social security numbers, the obvious, but sometimes it can be even information that you didn't realize is protected health information that falls under HIPAA. So HIPAA requires employers to implement policies and procedures to make sure that the organization is in compliance with HIPAA. And training is important and required under HIPAA. And it's not just for your employees who actually access and touch the protected health information. It is really intended for all of your workforce. And the training is supposed to be provided not just when the employee starts as a new employee, but also if there's any changes to your policies or procedures or to the HIPAA law or regulations. And in addition, it's best practices to have annual HIPAA training for all of your employees to make sure that they stay on top of it and they don't forget the important pieces. Next slide.
And just to follow up on that quickly, we want to make sure that we're following through with that HIPAA policy being reflected in your employee handbooks, right? We're not going to cover every single policy that should be in your employee handbook, but you definitely want to have that disclaimer and that follow-up that the employees can reference at any time, and so that we're documenting that training that you're doing. So switching gears a little bit to sort of the more traditional relevant federal employment laws that hopefully we're all familiar with that are on our radar. We have Title VII of the Civil Rights Act of 1964, which is the cornerstone federal anti-discrimination and employment law that prohibits discrimination based on race, color, religion, sex, and national origin. I have highlighted here sexual orientation and gender identity because, as some of you may be aware, there may be some challenges to protections based on these categories under the current administration. So just to recap a little bit, back in 2020, there was a big Supreme Court decision that came out in Bostock versus Clayton County, which said that Title VII prohibition on sex-based discrimination also prohibits discrimination based on gender identity and sexual orientation. So gender identity being how someone self-identifies as male, female, transgender, non-binary. Sexual orientation being who someone is attracted to, so gay, lesbian, straight, etc. And the current administration in January came out, one of their executive orders said expressly that the federal government is currently only recognizing biological sex of individuals based on their biology, quote, at conception, as either male or female, that this is not malleable, that it does not change, that it has nothing to do with what the administration is calling gender ideology. And essentially, the administration is saying we don't agree with this Supreme Court decision, and likely there will be litigation arising out of these issues in the coming months and years, depending on how these federal policies are implemented. The executive order does not specifically reference any information about sexual orientation, but it remains to be seen if at any time the administration will be attempting to challenge sexual orientation as being protected by Title VII. We also have the Age Discrimination and Employment Act, which protects employees who are 40 and older, and the Americans with Disabilities Act, which protects employees who are disabled, thought of as being disabled, or who have a record of disability. The Genetic Information Non-Discrimination Act, which prohibits discrimination based on genetic information. Next slide. USERRA, which protects employees who have a record or who are in the military. The Equal Pay Act, which requires payment of wages, the same pay for the same work for employees of different sexes. And that is becoming a hot topic because of more and more states are requiring pay transparency in job postings, and you may be operating in one of those states or a state that has a new law coming soon. New Jersey being an example where this summer there's a new law going into effect where employers are going to have to put certain pay rate information in all job postings. And so what that does naturally is it forces employers to have to say, well, once our current employees see what pay rate we're offering in this job posting for the same position, we have to make sure everything lines up, or that we can at least explain with legitimate business reasons why there's a disparity. So it's, I think, requiring a lot of self-reflection and internal auditing. And then, of course, we also have federal protections under the Immigration Reform and Control Act and Pregnant Workers Fairness Act, which requires reasonable accommodations for pregnant workers. I'm going to pause here and give the first CLE code for those of you who are looking for that. The first CLE code is 62413. 62413. And I believe I was told that that would be shared, I think, in the Q&A or the chat for a brief period for anyone who needs it. And of course, if you write it down and then lose your scrap of paper or delete your notes, we can make sure to get that information to you. But just one more time, the first CLE code is 62413. Okay, next slide. So I think we all hopefully have an understanding of what prohibited discrimination is in employment. Obviously, subjecting an employee to different terms and conditions of employment because of a protected status. So it could be pay, promotions, discipline, hiring, termination, benefits. Really, it can occur at any stage of employment. And when we think about discrimination, it's usually these kind of discrete acts as opposed to harassment, which is typically a pattern of behavior, or it's more conduct between employees. So there's a little bit of a nuance there. Next slide. So when we think about, again, types of discrimination and how these laws sort of translate into practice and where we need to think about our issue spotting, I am sure that those attending today and the people that we all probably generally interact with don't go to work and say, let me go to work and discriminate against women or discriminate against Asian employees. And let me create a policy which is really going to make these people feel other and really tick them off and just give them less benefits than everyone else. I would like to think that in 2025, that's not our mindset. And yet, you know, there's still a reason that I have a job where a big part of that is sorting through employee issues that come up, complaints with the EEOC and other enforcement agencies, lawsuits, class actions, et cetera. And it's often because we have the first scenario where there's a neutral policy that disproportionately impacts a certain population without us realizing it, or this third scenario, pretext, which I'm going to talk about in a second. So just to briefly touch on this disparate impact notion, so you have a neutral policy that disproportionately impacts certain applicants or employees. An example being that recently the EEOC reached a settlement with a company that used a third party for hiring and recruiting, and it had certain AI related programs, and they gave the recruiting company, you know, certain criteria that they were looking for, and unbeknownst to the employer, it resulted in the recruiting system excluding candidates over a certain age. That was not the intention of the employer. They didn't put anything in writing saying we don't want to hire people over a certain age. Here was the criteria they were looking for, and then lo and behold, the program was basically excluding older applicants from the pool of potential candidates. And there were certainly a lot of issues, you know, AI related there, which is a whole other can of worms that I could spend a whole day talking about. But that wasn't the intention of the employer. But there was still an impact on this population that was problematic. And unfortunately, that employer had to pay a six-figure settlement with the EEOC to resolve that matter. Facial discrimination is where an employer's policy is intended to discriminate against a particular class of people. So historically, there were perhaps policies where, you know, if you were hiring for a firefighter or a police officer, that the policies would require essentially only men to apply, or people who fit the physical description of certain men, that policies that expressly exclude pregnant women from applying. There can be some business-related justifications based on the need to perform physical fitness tests in very specific cases, but generally, obviously, if you have a policy that just on its face excludes a certain population based on a protected class, it's probably going to be an issue. Then we have pretext, is where a company does not admit to discrimination, but it argues some other legitimate reason as the basis for the adverse employment decision. So this is what we see a lot of the time. An employee is terminated because they showed up to work late for 6 months. No matter how many times you told them till you're blue in the face, they continued to show up with every excuse under the sun. You terminate them. They say, the employer is claiming that they terminated me for poor attendance, but really what happened is they terminated me because I complained about this illegal conduct. So the employee is taking the position that our legitimate reason of attendance is not the real reason for the termination. It's actually something else, which is discriminatory or retaliatory, that's prohibited by law. I saw a question come up in the Q&A. And I'm going to try to address Q&A as we go along, depending on time. So if I don't get to them as we go, we will circle back at the end. So a question came up. What is the thinking on screening applicants based on how far away they are from the facility? So I think this falls into a category of, while there is not necessarily a law that expressly says that that is illegal to do, it's not really our concern. Our concern is, can you show up and do the job and meet the criteria based on you're telling me you have these, the right academic training, the right experience. You seem like a good fit for the position based on your skills and abilities. And then it's that person's job to show up. So I would not get into that unless the applicant expresses a hesitation about commuting, about start times, about scheduling. Then it's likely that you may have an issue. But if they don't bring it up and you're very clear about the expectations, then I would not use that as a basis to exclude anyone, because it could be viewed as, let's say you are in a suburb and based on traffic, you think, someone living in the city is going to have a really hard time getting here and it's going to make them unreliable. Well, you may not be thinking about that applicant as belonging to a certain protected category, but if you're excluding applicants from a certain community within the city, they could feel like they're being excluded because of a protected class. So, it could kind of snowball from there. Okay, next slide. Next slide. I wanted to quickly just give an overview. I just pulled these stats a few days ago. And I pulled them because, there's no way around it that there's a lot of changes happening at the federal level in terms of enforcement agencies, who's working at the Department of Labor, who's not, who's working at what agency, where they're going to fall from an enforcement perspective. And as a reminder that, they've still been very active, but also the State Department of Labor and the State Division of Human Rights are just as active as they've ever been, if not stepping up their enforcement action. So a lot of the calls I've been getting recently are state, the equivalent of EEOC charges or state audits related to wage and hour issues. So I'm not going to read every line, but suffice to say, in states throughout the country, they are just raking in millions of dollars in settlements for discrimination claims that come to their attention, that are actually investigated, and thousands and thousands of charges are still being filed every year. Next slide. Another example from the wage and hour perspective, according to the Economic Policy Institute, in the last couple of years, the DOL collected $1.5 billion in unpaid wages for workers. And I actually found what was very interesting is, so every state has an equivalent agency, right? Regardless of what the federal government is doing, the state has its own Department of Labor, where their job is to also investigate claims of unpaid wages. Massachusetts has a really fun tool where you can go online, look up employers by name, how many claims are filed against them, whether they're pending or they've been settled, and you can look up by industry. So in the healthcare industry alone, in the past 2 years, 930 complaints of wage and hour violations just in Massachusetts. So if you're in Massachusetts and there's a complaint, it's the fact that the complaint has been filed is public information. So, this is a big deal. It's not going anywhere despite what may be happening, based on politics and things like that. And all these figures, of course, do not include private actions and class actions. Those are a whole separate can of worms and often even more expensive for healthcare providers. Next slide. So we want to talk a little bit about something that Allison and I talk about often, which is just from the start of the employment relationship, making sure that we're starting off on the right foot with our offers of employment and our employment agreements. Next slide. So we wanted to give an outline, and I know that for some of you who are maybe part of larger organizations, you're used to having a template offer letter that you have for your hourly employees or employees in certain positions that you just fill in the name and the address, print, and it's ready to go. And it's great to have a standard form. We want our clients to have those to, again, have consistency and make sure that we have the legal requirements that we think would best protect your operations. But it is important, by the way, to review those from time to time and make sure that they are consistent, that they're reflecting the actual needs of the position and the key terms that we want to provide up front. And that, we don't need to make any changes to them just based on operations or the goals of the position. So, of course, we want to make sure we're clear about the position, if it's full-time, part-time, exempt, non-exempt, if there's any specific hours or schedule. And then if they're getting paid a salary or hourly rate. And equally important is that they are being employed at will. Most of my clients have gotten pretty good at just including this disclaimer in bold, underline right off the bat. If you don't have it or it's not bolded or underlined, I suggest that you review your offer letters and take a look at that, because it's very important that even though it should be maybe common sense or a default that unless you give someone a contract for a specific term, they are at will, we want to put it in writing. We want to make it really clear so that there's no confusion. Next slide. Another really important term in an offer letter is if the offer is conditioned on completion of background checks, drug testing, signing a confidentiality agreement, providing the correct documentation to show that they can work in the United States, reference checks, whatever it may be. I often see offer letters where there is a reference to these things happening, but it doesn't actually say that the offer letter is contingent on these items. And so even though someone may be at will, and yes, you can terminate them if they're at will for failure to complete any of these items, why leave this up to confusion or have any question of, a different interpretation as to what is expected? We don't want to have any unnecessary claims or issues with someone. I've seen situations where people are moving for a job, they're relocating, and then an offer is pulled, and then they have a big issue. And it's like, we want to make sure we told them in black and white what the requirements were for the position and that they're accepting those responsibilities before they accept the job. I think it's also helpful to give an overview of your benefits package without getting into too much detail. From my perspective, just making sure that it's clear that we're providing any sick time that might be required by law, even if you don't go into the details of the policy, just a note that, PTO is going to be provided as required by law, or the hours you're going to provide is also helpful as well. Next slide.
So as Lisa mentioned, we talk a lot about these types of issues, and a big part of my practice is both drafting and reviewing employment agreements for healthcare providers, a lot of licensees, a lot of physicians. And so I wanted to just go through and hit at a very high level some of the big points that are important in the employment agreement, and that are often subject to a lot of negotiation. The first, of course, is compensation, right? And in the physician world, we usually have, I would say, 3 buckets of types of compensation. One is just the street-based salary. The negotiation is, are there annual increases? How does that number go up or down? RVUs is a big one lately. So those that do or don't know it, Medicare sets sort of a value for each service that's provided, and then the employer will pay a dollar rate for each RVU. Sometimes there are reductions in compensation if you don't meet certain RVU targets, but RVU compensation has become more prevalent nowadays in physician employment agreements. And the other is collection-based compensation, although I would say that used to be very popular and has become less popular in recent years, is paying a percentage of collections for services provided. Of course, in all cases, we're always concerned that physicians being paid fair market value for their services to avoid any sort of anti-kickback or other regulatory issues. Fringe benefits, Lisa hit on a few in her prior slides. A couple that come up often in the employment agreements that I work on is who's paying for licenses, CDS, DEA registrations. What about continuing medical education? Is there a budget for that? How does that work? Medical staff dues, usually an employer will pay those. If it's the facilities where the employer wants the employee to work, board certifications, and the other ones is waiting periods, right? To just discuss that I find you should be really upfront about that and make sure the employee is aware that there may be waiting periods for certain things.
Allison, we got a question about withholding from final paycheck for departing employee physicians tail coverage. I will answer from my perspective from the employment law compliance side.
Sure.
Deductions from pay are entirely dependent on what state the employee works in terms of what you can deduct or hold back from a paycheck and what is not permitted. In most cases, you need a specific agreement with that employee to make that kind of a deduction. We need to, just be cautious about not inadvertently triggering any issue with the wage and hour law. And it could be something that you put in writing at the start of the employment relationship to help curtail that issue, but it is a state law issue for sure.
Great question. We're going to talk about malpractice insurance in the next slide, but I certainly include in the employment agreement a right to offset for costs like that, like a tail insurance. I think it's a good point. Outside activities, I don't know if it's more for physicians than other employees, but they always are tinkering and doing other little moonlighting and other things, writing, speaking, those types of things. So usually there's a provision in the employment agreement about how that works. Does the employer need to approve all outside activities? What if it's not healthcare related? And then the other thing in connection with outside activities is malpractice insurance for those outside activities, right? We want to make sure that the employee is going to get their own separate malpractice insurance to cover any services that are not being provided on behalf of the employer. We want to be clear that it's going to be done on their own time without the use of employers' resources. And then the other one that comes up in this category is intellectual property, right? If something is developed by the employee while they're employed by the employer, how does that work? Who owns it? Who pays for it? Things like that. Non-compete, non-solicit, confidentiality, we're going to hit on that. That's a big one in another slide. And then term and termination, of course, putting in a term of employment, but usually there's a right to terminate without cause on a minimal amount of notice. So the term to me is often irrelevant if a party can terminate on 60, 90, 120 days without cause. The other are for-cause termination provisions. Of course, Lisa's going to go through some of that towards the end of our presentation, but usually my employment agreements include a laundry list of ability for the employer to terminate for cause, and usually a catch-all at the end, right, for any other for cause reason. The other one that comes up is if the employee has medical staff privileges at a hospital because that employee has been required to provide services at that hospital on behalf of the employer, just whether or not those staff privileges are linked to the employment and whether we're going to ask that employee to resign their privileges when they leave and waive any right to a hearing. And then the last point on termination to think about in the healthcare context is any state reporting or national practitioner data bank reporting. So if there's termination for cause, whether or not the employer will be obligated to make certain disclosures, whether it's the State Board of Medical Examiners or that national practitioner data bank, but that's something that we can help work through. Next slide, please. Malpractice insurance. So this is obviously a requirement for our physicians. And the big question is occurrence versus claims made. Most of the times the employer is the one that's providing the malpractice insurance, but if they are not, we want to make that very clear in writing that the physician would be obligated to maintain, or the other licensee would be obligated to maintain the malpractice insurance. Of course, occurrence is usually more expensive, but provides the broader coverage for whenever the claim is filed. Claims made, which is usually less expensive, will provide the coverage only when you have the malpractice insurance in effect. So that's where that tail insurance comes up, tails and noses. So tail is what you buy at the end of a claims made coverage. Nose is something that's tacked on to the next coverage that you have. So it's sort of at the beginning. That's why they call it the nose versus the tail. But obviously that's a negotiated provision about who pays for it, right? Does the employer pay for it? Is the employer obligated to pay for it? Someone brought up a great question about, having a right to offset. We usually have some language in there if the employer doesn't, if the employee does not purchase the tail insurance, that employer can go ahead and do that and then offset the cost against what the employee is owed. And then sometimes we come up with a compromise, right? So employer pays the tail insurance in certain circumstances, employee pays it in other circumstances, maybe if they leave without cause or they're terminated for cause. Self-insurance comes up a lot with the hospital employment, so that kind of raises some other issues. Usually I see a higher coverage when there's self-insurance, but that's just another thing to be aware of, and how that works, and again, how that tail insurance works with your self-insurance. And scope of coverage, we kind of hit on that in the prior slide, but just being clear that the malpractice insurance that the employer provides is only going to cover services provided on behalf of that employer. So if that employee is permitted to moonlight or work somewhere else, they better make sure that they have separate malpractice insurance for it. Next slide, please. So restrictive covenants, obviously this is a big one. It's a state-by-state analysis, and certain states have different rules on it. I think Lisa will let us know about the new law in Pennsylvania on non-competes. Good old New Jersey has tried for several years to adopt a law about restrictive covenants and has not been successful. Most of you probably have heard about that FTC rule that was adopted in April of last year, that was supposed to go into effect in September of last year. It really eliminated a lot of the restrictive covenants, except in certain circumstances it related to whether the employee was a senior executive, but did not permit new restrictive covenants. And there was an exception for selling the business, right? A lot of times we have restrictive covenants on a seller of a business. Those were still going to be permissible. But in typical fashion, right before the effective date of that rule, there was one court that partially banned the rule, and then another court that fully banned the rule. So as of right now, that FTC rule is not in effect. My understanding is that it was appealed, but in light of the current administration, we don't anticipate that FTC rule coming back to life. So unless your state specifically prohibits it, restrictive covenants are still part of the day-to-day life of healthcare attorneys and part of our employment discussions. So just at a very high level, restrictive covenants have to be narrowly tailored to protect a legitimate business interest of the employer. Can't be overly broad, can't cause undue hardship so that employee can never find another job. And it also can't injure the public. So the famous case, at least here in New Jersey, was about a very specialized neurosurgeon that wasn't able to provide his services because of a restrictive covenant, but there was really others in the area that did not do that. And so the court found that the restrictive covenant was too broad, that his services were needed in the area. Non-competes usually have a time restriction and a geographic restriction. I usually say in New Jersey, a 2-year, 10-mile restrictive covenant is fairly standard, but that really depends on where you are in the state, and certainly state by state as to whether or not the amount of time or the geographic area is reasonable. There's also a lot of negotiation about exceptions to restrictive covenants, right? Should the employee have no restrictive covenant if employer terminates without cause? Those are things that we often will battle out in employment agreements. In addition to non-competes, there's also those non-solicitation provisions. Those also usually have a time restriction. Again, in New Jersey, I would say the standard is 2 years. It prohibits the employee from soliciting patients, employees, independent contractors, referral sources, contractual relationships, can be a broad list of things that prohibits the employee from soliciting while they're employed by you, and then for a period of time after. Again, sometimes there's exceptions to that we'll negotiate in the employment agreement. Confidentiality, obviously, we'll always have that type of provision in there. I know Lisa will put it in employee handbooks as well, so that an employee cannot use or disclose confidential information of the employer. And the last one I just wanted to raise was non-disparagement, becoming more common in my employment agreements where we say to the employee, you cannot say bad things about the employer when you leave, can't say it on social media, shouldn't be saying it around town, just trying to put some sort of restriction on them going around talking poorly about the employer.
Just to quickly follow up on that, Allison. So, and we had a question about this, so we, obviously, state by state assessment. There are some states like California that have just outlawed non-competes altogether, regardless of industry. No non-competes for individuals in California, and then there are some states where, it depends on the scope of the agreement and if it's reasonable to protect your business interests. And then there's a few states that have actually narrowed in on healthcare professionals in particular. So in Pennsylvania, as of January this year, the state has outlawed non-competes for healthcare providers unless the non-compete is for no more than 1 year and provided that the practitioner was not dismissed by the employer. So it would have to be a situation where they're leaving, the non-compete is for less than 1 year, and that applies to certain types of healthcare providers, but most of whom that we would be concerned about. You also have to, by the way, give notice of that practitioner's departure under that law, which is significant. So if you have questions about that, please reach out to your counsel for assistance. Maryland is another one. So effective, it's going to be July 1st of this year. Non-competes for healthcare professionals licensed under the Health Occupations Article who provide direct patient care will be banned unless they earn $350,000 or more. And then if they earn more than $350,000, they have to be limited to 1 year and 10 miles. And then there's some other nuances there as well. So there are restrictions coming down the pike for, it seems like, more states for healthcare providers who have certainly lobbied and tried to bring their causes to the attention of legislature to say, hey, we want to be able to go down the street and perform this surgery, and we don't want to be bound by these non-competes. So just, be careful depending on where the employee is working. Next slide. Next slide. So we're going to switch gears. And looking at the time, there's definitely going to be slides that we have in our deck that you will get after the presentation that we're going to flip through. And we will, of course, remain available after the presentation if you have questions. But I think the hypotheticals are useful and sometimes the best way to kind of put things in practice. And I like to be a little sneaky and put hypotheticals before substantive content as a refresher. So we're switching gears to compensation for our employees to talk about some general principles of compensation and compliance with wage and hour laws. So that's where we're transitioning to. So in our hypo, Riley, which is one of my daughter's names, so shout out to Riley, is an experienced and trusted nurse, normally works full-time Monday through Friday. Last week, she also picked up a shift on Saturday to cover for another nurse who suddenly called out sick. Riley is paid a salary and offered to work the extra shift, even though she was not required to do so. A few weeks later, Riley asked if she should have been paid overtime when she picked up this Saturday shift. Is Riley entitled to overtime pay? I think you guys can see the chat function. Gavin or Brittany, is that correct? Do they have the chat function?
They can submit anything through the Q&A if needed. Okay.
All right. We'll do it a different way. I was going to have you guys submit some responses, but it's fine. So just think to yourself, is Riley entitled to overtime pay? Well, this is a scenario where looking at this, what should come to mind is that we need more information about Riley. We know that she's a nurse, but what kind of nurse is she? Under the Fair Labor Standards Act, or the FLSA, which is the federal law that provides our wage and hour laws and regulations, there is a distinction between an RN and an LPN. And if she is working as an RN and has the appropriate academic background and she's performing the core duties of an RN, chances are she's not entitled to overtime just because she works an extra shift. She's paid a salary. We need to know what her salary is and to make sure that it's the same every week. But if she's an LPN, she probably is entitled to overtime, even though she's paid a salary. So being paid a salary is not the end all be all, and it does not mean that you are automatically exempt from overtime. Next slide. All right, in this scenario, one of your physician assistants splits her time between her regular PA duties and also providing administrative support to the practice, including scheduling and billing duties. Some weeks she spends more time in her PA role, other weeks she catches up on her administrative duties. The employee is paid the same daily rate for all work performed, and her paycheck is usually the same because her work schedule stays pretty consistent. But this month, your practice serviced more patients than usual, and you realize that this physician assistant worked an average of 45 hours per week instead of her usual 40-hour schedule. Is this physician entitled to overtime? So I think in this hypo, I laid a little bit more clues that there might be there should be some alarm bells going off for everybody reading this to say, hold the phone. So we have somebody who is performing two different jobs, who is not paid a salary, and who worked more than 40 hours. So whenever we have that, we need to pause and really dig down and say, is this person exempt based on the criteria provided by law? So in most cases, the people we're talking about are probably going to be exempt under the Learn Professional exemption of the FLSA, and most states follow that exemption. So for that exemption to apply, this person would have to earn a salary of $684 a week. She gets a daily rate. And if you read the regs, which I guess for better or worse, get the pleasure of doing as part of my job, there can be situations where a fee is acceptable instead of a salary, but that is really for like one-off fees for a big project. So if an artist is commissioned for a big painting and they're paid a fee for that painting, sometimes they can still be exempt. It's not usually for repetitive fees like a day rate. So right there, we probably have a problem. So she usually gets paid the same, but maybe not always the same. And it obviously depends on how much work she's performing. So right off the bat, seems possibly unlikely that she's going to qualify. And she has to meet all of the elements of the test to be exempt. The next is that she has to be performing work that requires advanced knowledge in a field of science or learning, and that is acquired by prolonged course of specialized intellectual instruction. So the FLSA does have specific regulations for physician's assistants to explain when they are covered by an exemption, but here she's splitting her duties. So you may have hired her as a physician assistant, but if she's spending, half her time doing these administrative duties, is her primary duty really this working in a field of science or learning and performing that work requires that advanced knowledge? So here we may have a distinction between her offer letter and her job description and what she's actually doing. And what the law cares about and what a court would care about and what the government would care about is what she is actually doing on a day-to-day. So it seems unlikely here that this person will be exempt, but again, more information will be required. And that's the level that we want to drill down into when we're doing these assessments. Next slide. So I hope everyone is more than well aware that for non-exempt employees who work more than 40 hours, the general rule of thumb is that they have to be paid time and a half their regular rate of pay per work week, not per pay period. That is a common misconception, especially for some of our smaller practice clients. But you need to make sure that whoever your payroll administrator is, whatever platform you're using, that they have their formulas set up appropriately. The vendors are not a one size fits all. Some are definitely better than others at doing this, but it's based on their work week. Okay, next slide. And then if we have an employee that we're not sure if they're exempt from overtime or not, or maybe they fall in a gray area, there's different levels of assessments we need to do. So are they paid a salary? Is the salary the same every single week, regardless of productivity? What are their job duties? Are their job duties considered exempt? And then we go through each of the tests that may apply depending on the type of job that they're doing. So I've had situations where, you could have the best, executive assistant to, your head physician that you've ever seen. She knows every schedule. She knows exactly how the doctor likes to do something. She's worked for your practice for forever. You think she's great. She's never complained. She's always on time for work. And she's great with your computer and the insurance companies, etc. That is great. But do her job duties meet the exemptions under the law? I don't know. When we have anyone doing clerical work, I get really hesitant. And we should all be really careful that we're not just classifying someone as exempt because we're paying them a salary and they're a good worker. Next slide. Another hot topic that still comes up all the time that gets us in hot water, especially when we're being audited by the government, but sometimes this can come up in private litigations also. Meal and rest breaks, okay? If the employee is taking a break of less than 20 minutes, that is a paid break. There should be no docking of time. And, people are going to need breaks throughout the day. So we need to figure out, do they have a schedule? How are they getting permission? They should not be penalized for taking a break that everyone else gets. And then meal breaks. The big one with meal breaks is auto deductions. Anytime if you have, if you get into litigation or you're being audited and your payroll just says 30 minutes, 30 minutes, 30 minutes every single day for a break and there's no clock in, clock out, that's going to be challenged. It's going to be a problem. So we need to rethink that. Next slide. Can you actually skip to the next slide? I have here a checklist for you all to review after the presentation and to think about internal audits and how you can review your own, payroll systems to make sure that you're issue spotting and that you're in compliance, and how to identify red flags to make sure that you don't end up in hot water. We want to be performing these regularly. I know they're tedious. I know they're a pain, but that's how you're going to make sure that nothing has slipped and fallen between the cracks. Next slide. Next slide. All right, we're going to jump into like the fastest review and check in on our FMLA and accommodation section that you've ever seen. But as a reminder, and to be continued, of course, after the presentation for any questions and beyond. Because we get questions on this all the time, FMLA, ADA, how do they interact? People are taking leave and they request more leave, and when does it end? So FMLA, the federal law applies to employers with 50 or more employees, 12 weeks of unpaid leave for certain covered reasons. A lot of states have their own version of this for smaller employers with certain differences. So it depends, again, where is the employee working? Those are the laws that apply. Next slide. So this is FMLA applies if someone has a serious health condition, they're caring for a child, spouse, or parent suffering from a serious health condition, or due to the birth of a new child or bonding with a new child. FMLA applies to a wide variety of serious health conditions, anything that's really requiring inpatient care or continuing treatment by a healthcare provider that's lasting more than a couple of days. So if somebody is starting to mention that they need continuous time off for a condition or they're caring for someone, a light bulb should go off that we need to talk to them. We need to get our FMLA forms out, and we need to be proactive. Next slide. Then we want to be thinking about if someone needs time off or they need an adjustment to their schedule or they're having difficulty doing their job and they mention anything medical. Is this something that's covered by the Americans with Disabilities Act or the ADA or a state law equivalent? Does this relate to workers' comp? Does it relate to any of these other laws that provide rights and protections for employees regarding time away from work? Okay, sometimes they overlap, sometimes they intersect. It's like a puzzle. You got to put all the pieces together. But the default needs to be that it is our obligation as the employer, if someone gives a hint that they may need assistance doing their job or to take time away, come back to work because of a disability, a medical condition, we need to be proactive in that interactive process and gathering the appropriate information to determine if they're covered, if they're entitled to any time off or other accommodations, or if the request is unreasonable. We cannot sit back and wait for them to come to us with magical language. And just because someone already took FMLA does not mean that they're not entitled to any other time off. There's no magic number for how long someone can be out of work until it becomes a undue hardship on us. And that has to be more than just something that's annoying to deal with. A week or two after FMLA, most courts are not going to say that's an undue hardship. Okay. We have to really think about the position, how we fill the position in their absence, what they're doing, the impact on the staff. If they request an accommodation, that's very costly. All of these areas have to be considered. Next slide. Next slide. All right, second CLE code. And we want to think about paid sick leave also in conjunction with all of the federal laws that I just covered. Many of us are operating in states that have a sick leave requirement. And so not only thinking about our policies that we have for sick leave, but also thinking about how that interacts with unpaid leave or even paid leave that's required by the government. So when an employee requests time off, is it for a single day? Is it for a longer period? Do they have time in their leave bank? What does your policy say in terms of which type of leave applies first? What information have we gathered about the reason for this absence? Balancing that with, in most cases, if your employee is working in a state that has a sick leave law, we generally cannot require a doctor's note after a one-time absence, right? It's usually 3 or more days, consecutive days out before we can get a doctor's note. So it requires that it's all really within that interactive process of finding out, is this a one-time thing? Is this a disability where they're getting physical therapy every 2 weeks because of a disability and they need a schedule change? What is really going on here? And we have to peel through all the layers of the onion to get to the bottom and find out what's going on. We do have, I'll give the second CLE code real quick. It is 85209. 85209. That is the second CLE code, 85209. And just circling back to your paid sick leave policies, there's not a one size fits all. I know a lot of times it seems convenient and easy to just get that PTO policy that your payroll company is offering to you as part of their package, or that maybe you found online. Maybe even that ChatGPT prepared for you. I really don't know at this stage where some of these boilerplate policies are coming from, but I see a lot of them and they're not tailored to your practice. They're not tailored to your business needs. And you need to make sure that they cover what is required by law in terms of sick time, or in some cases, even vacation payout if you're in Massachusetts or California or other states that require payout of vacation upon leave. But how it really works, from the perspective of your day-to-day management. So the policies are only as good as they are in reflecting your actual culture and day-to-day operations. So while having something can be better than nothing, if it's just the literally a regurgitation of the law, it's not really going to help your team when employees have questions about, well, what about this day and what about that day, and what about we all want to take vacation off the week of Christmas, and I want to take 3 days off because my son has a school play, and then next week I want to take 3 days off because he has a scheduled surgery. So how do all those things fit into your policy to make your lives easier in terms of administrating the PTO? So we want to be constantly looking at that as well. As I mentioned, we had a lot to get through today. You can go back to the previous slide. There's going to be some other slides that you'll see in your materials that have some best practices, some hypotheticals to think about as they relate to your day-to-day practice of administering leaves and accommodations. And I know we got through a lot, but like I said, we'll remain available for additional questions after the presentation. We do appreciate those of you who submitted questions during our discussion here today. And with that, I'm just going to pause for now because I've been talking at you a lot, and just open the floor for any additional questions that you may have at this time.
And Lisa, while we're waiting for those questions to come in, I'm just going to read the final piece. First, we'd like to thank you on behalf of Saul Ewing for attending the webinar. Our team is going to add a survey link in the chat box. But please remember to keep an eye out for the thank you email with the program materials and the CLE verification survey so that you can submit the reporting codes from today's webinar. Again, we'll do our best to answer any questions that you have of people sticking around, but certainly both Lisa and I are available by email after to help with any questions.
Any questions? Don't be shy.
I ask Lisa questions all the time.
All right. Well, I'm not seeing any pop up. So thank you all for joining us and for your participation. And we hope to speak to everyone soon. Have a great rest of your day.